Hello everyone! In this video, we will discuss to you the rules and supervision of probation. So what is probation? Probation is a privilege granted by the court to a person convicted of a criminal offense to remain in the community instead of actually going to prison or jail. In addition, probation does not confine to prison a sentenced prisoner but rather release and undergo personalized community-based treatment. So what is the purpose of probation? First, to protect the society through controlled programs of supervision of offenders. Next, to promote the correlation or correction and rehabilitation of an offender by providing with individual treatment. Next, to provide opportunity for the reformation of a particular offender which might be less probable if he were to serve a prison sentence. Next, to prevent the commission of the offenses. And lastly, to reintegrate the offender into the society. So what are the advantages of probation? First, the government spends much less when an offender is released on probation. Then, that offender may be placed behind bars like jails or prison. Next, the offender and the offender's family are spared with the embarrassment and dishonor brought by imprisonment. And lastly, the offender is able to continue working and can therefore earn income, pay taxes, and pay the damages that he has done to the victims.
Short history of probation in the Philippines. The word probation originated from the Latin word probare, which means to test or prove. It is originated in England in the year 1841. Probation was introduced in the Philippines during the American colonial period in 1898 until 1945 with the enactment of the Act number 4221 of the Philippine Legislature on August 7, 1935. In 1972, House Bill number 393 was filed in Congress, which would establish a Act of 4221 that struck down the 1935 law as unconstitutional. Congressman Teodoro C. Natividad and Ramon Bagatsing introduced an act establishing probation in the Philippines, providing probation offices, therefore, and other purposes. On July 24, 1976, PD 968, also known as Adult Probation Law of 1976, signed into law by President Ferdinand E. Marcos Sr.
Where and when shall the application be filed? The application shall be filed with the trial court that tried and sentenced the offender at any time after conviction and sentence, but within 15 days after promulgation of judgment. So how someone can be able to apply for probation? First, apply within 15 days from promulgation of judgment. Second, the court will suspend the execution of sentence and refer the application to the proper probation office for the conduct of post-sentence investigation or PSI. Third, the probation officer must submit the post-sentence investigation report within 60 days upon receipt, but the period may be extended in mysterious cases for a period that will be approved by the court. 4. Pending submission of the PSIR and resolution of the application, the defendant may be temporarily released under bail or be released on recognizance of a responsible member of the community. If defendant is incapable of posting bail, who are qualified to apply for probation. Any sentenced offender not disqualified can apply for probation before serving their prison or jail sentence.
Who are disqualified for applying probation? Those who are sentenced to serve a maximum term of imprisonment for more than 6 years. Those who are convicted of any crime against national security. Those who have previously been convicted by the final judgment of an offense, punished by imprisonment for more than 6 months and 1 day, or fine of more than 1,000. Those who have been once of probation under provisions of this decree. Those who have already serving a sentence at the time the substantive provisions of this decree became applicable pursuant to Section 33, and those legally disqualified under the special penal laws, and these are offenders found guilty of any election offense in accordance with Section 264 of Batas Pambansa bilang 881 or the Omnibus Election Code. And next, offenders found guilty of violating RA 6727 or the Wage Rationalization Act as amended. And last, offenders found guilty of violating RA 9165 or the Comprehensive Dangerous Drugs Act of 2002 except in Section 12, 14, 17, and 17.
Do you think that all qualified convicted person can be automatically granted with probation? Well, the answer is no. The court will not grant probation if, after investigation, the probation officer finds that the offender can be treated better in an institution or in other places for correction. The offender is dangerous risk to the community, or probation will lessen the gravity of the offense.
When probation is granted to a convicted person, these are the conditions imposed by the court. The probationer must appear before the probation officer within 72 hours from receipt of said order. Report to the probation officer at least once a month at such time and place as specified by said officer. Not commit another offense and comply with any other condition imposed by the court.
Hi, I'm Jesus Civiliano. The court may also require the probationer to first, cooperate with the program of supervision. Second, meet his family responsibilities. Third, devote himself to specific employment and not to change said employment without the prior written approval of probation officer. Fourth, undergo medical, psychological, or psychiatric examination and treatment and enter and remain in a specified institution when required for that purpose. Fifth, pursue a prescribed secular study or vocational training. Sixth, attend or reside in a facility established for instruction, recreation, or residence of persons on probation. Seventh, refrain from visiting of houses of ill repute. 8. Abstain from drinking intoxicating beverages to exist. 9. Permit the probation officer or an authorized social worker to visit his home and place of work. 10. Reside the premises approved by and not to change his residence without the prior written approval. And lastly, satisfy any other condition related to the rehabilitation of the defendant and not unduly restrictive of his liberty or incompatible with his freedom of conscience.
How long is the period of probation? A. Not more than 2 years if the probationer was sentenced to imprisonment. B. Not more than 6 years if the probationer was sentenced to imprisonment of more than 1 year. How many times can one be granted of probation? An offender or a convicted person can only be granted of probation once in their lifetime. It means that once you already experience probation, you will no longer be granted of it for the second time around. Once is enough, twice is prohibited.
What happens to a probationer if the conditions of probation are violated? If the probationer commits any violation, the probation officer will investigate the alleged violation, and if it is established, a report is submitted to the court. Depending upon the nature and seriousness of the violation, there can be modification of the conditions or revocation of probation by the judge. There is also the possibility of arrest, including criminal prosecution of probationer in the event of commission of another offense. The revocation proceeding is summary. If the court finds the probationer guilty of serious violation of the conditions of probation, the offender may be ordered to serve the original sentence imposed.
What are the manner of supervision that a probationer shall be monitored? We have first the maximum supervision. It is a form of supervision wherein the clients are required to report more than twice per month. Next, the medium supervision. It is a form of supervision wherein the clients are required to report at least twice a month. And lastly, the minimum supervision. It is a form of supervision wherein the clients are required to report to the probationer officers once a month.
Here is the probation supervision process. First, upon granting the petitioner's application for probation by the court, he or she will be placed under probation and will be called as probationer. He or she will be undergo probation supervision under the supervision of probation and parole officer and will be obliged to comply with the mandatory and other probation conditions, such as those conditions presented on the earlier part of this video. Next, to carry out the compliance with the terms and conditions of the probation and to ensure that reformation is achieved, the probationer and his or her probation officer will prepare the Supervision Treatment Plan or the STP that will embody the goals and objectives of the rehabilitation program. The STP will be regularly evaluated by the probation and parole officer for the appropriate action and intervention. During the supervision period, if the probationer fails to show up at the office after the reasonable time, then he or she is considered as absconding probationer. In effect, his or her probation may be revoked.
If a probationer is not compliant with the probation conditions, it may result to modification of probation conditions of the probation officer may file a violation report to the court, indicating the violation committed. Due process shall be done and the accused shall be given a chance to be heard. If reasons are meritorious, the probation conditions may be retained or modified. If not reasonable, then the court may, upon its discretion, would issue a revocation order. In this regard, probationer will be ordered to serve the original sentence imposed to him by the Honorable Court. If probationer has substantially complied with the probation conditions, the probation and parole officer shall recommend the discharge of the probationer for probation by submitting a final report, thereby retaining to probationer all his/her civil rights lost by virtue of the offense committed.